In New Zealand employment law, the minimum entitlements such as holiday pay, minimum wage, rest breaks, and leave are protected by statute. They can't be contracted out to. To reinforce this protection, MIMBI, that's the mediation service, requires every settlement agreement signed under Section 149 of the Employment Relations Act includes a clause confirming, wait for this, neither party has agreed to forego minimum entitlements. Let me repeat that. Neither party has agreed to forego entitlements. So while this clause seems straightforward, its legal implications are significant. Can an employee still raise a claim after signing full and final? What happens to the minimum entitlement? There was a misunderstanding in regards to holiday pay. Could they raise that afterwards? And does this clause affect the finality and the flexibility of the mediation agreements? Today, we're fortunate to be joined by one of New Zealand's most respected legal minds in the field of employment law. Barrister Chris Patterson has over 2 decades of experience before the Employment Relations Authority and the Employment Court, and I think other higher courts too, and other key jurisdictions as well. Chris is renowned for his practical insight, strong advocacy, and deep understanding of employment relations. Chris, welcome, and thank you for coming.
Oh, thanks, Max. It's actually 3 decades, but I stopped counting after the first.
Well, I was thinking the same, because in the 90s I met you, way back in time.
Yes, it was a long time ago. Last
so
century.
We're both fossils.
Yeah. And the other century. Yeah. Good to see you.
I can still remember you on the street somewhere.
Yeah.
Thanks. Anyway, we were both chatted and got on very well ever since.
Yeah.
So, what's your thoughts on this legislation? Tell me, why do you think they're insisting on this clause being inside every settlement agreement?
I don't know why they're insisting on it at all. I mean, I guess the critical point is, well, what is their role? They're being asked by 2 parties to an employment relationship that have been in a dispute or a personal grievance of some form, let's just say a disagreement, to assist them in a formality to give effect to an agreement that they've reached. The legislation's fairly clear as to what their role is. I mean, their role's not there to check that minimum entitlements have been paid or are going to be.
And do you know what, Chris? I mean, you'll relate to this, but the average Joe Blow pops along there to mediation to get help with a problem with their employer.
Sure.
And they sit there in awe of the mediator because the mediator knows more about the law than anybody. So they take that as an authority, like a knowledge person of it. And then they go and see this, and the naive person would interpret neither party has agreed to forego minimum terms. That means they're going to protect me because they uphold the law.
Yeah,
and that's not quite really what it means, is it?
I'm not sure that that's what their statutory role is. I mean, the legislation provides that there is this mediation service that is employed by the chief executive of MIMBI. And it sets out what their role is to do. I mean, their role isn't there to protect. That's not what except to the effect of making sure that both parties understand that by signing the agreement it's going to be enforceable and you can't cancel it. But that's as far as the legislation says. I mean, they're effectively elevating their importance, if that's what they're doing, or their role beyond what the legislation says.
Well, it's what people treat them as. And I've always said to my people when I go into mediation, treat them with respect. They are there to oversee things, so if you treat them with respect, you're going to get the best out of them. And I agree with you, they don't actually have any power at a mediation. And that's the bottom line. They're very persuasive, but the other thing they do is, in my view, is my experience with them is immediately drop, well, not immediately, after a while, will drop to the bottom line and saying, well, what can you afford?
Yeah, I guess
that's unfair.
I guess the wider question comes down to this is, what's their role?
Exactly.
So mediation's been actually quite a key part of our employment, I guess, landscape for a long time. I mean, sort of going back to 1908.
Well, I remember the Labour Relations Act, so that's how far I go back.
Yeah, well, I was thinking back even to the Arbitration Conciliation Act.
Because the tribunal and the mediation service were one party, weren't they?
Yeah, so there was this kind of dual hat role that tribunal members could have, where they could act as both mediators and as effectively deciders of fact and law as tribunal members. For those that are aware of what used to be called alternative dispute resolution, I don't really like that phrase. It's just dispute resolution.
Mm-hmm.
There was this concept of med-arb, where a mediator could become an arbitrator, and the parties could contractually agree to that. But going back on our legislative landscape, New Zealand's had a very long tradition. I mean, it's nearly 120 years of the state providing a mechanism to help resolve disputes in workplaces, and the piece of legislation that was really at the forefront of effectively the Western First World was this arbitration conciliation legislation, and part of that was conciliation, and it was the state would assist the parties to sort their own problems out, and if they couldn't, it would arbitrate it. And then, as you mentioned, the Labour Relations Act carried on that theme. It's carried on by the Employment Contracts Act, and our current piece of legislation, the Employment Relations Act, carries it on again, but in a different guise. It does separate it out, but it doesn't fundamentally change the fact that a mediator's role should be, and always has been, to be an independent third party. Acts as the agent of reality and assists the parties to understand perspectives and guide them towards a resolution. But it shouldn't impose what the terms of that resolution is. And I think the clause that you're referring to about minimum wage and saying, well, we're not going to sign this off unless this clause is in there, is actually imposing effectively a term that isn't in the legislation and hasn't been dictated by our legislature. And I don't know where they got it from, but it's a...
I recall it coming in, and I remember he's still there today, one of the long-standing mediators explained to me that they had some difficulty one time with an individual really pushing them around and about what they were doing, and so they put it in there for their protection. That's what I understand from this guy. But getting back to it and help the people that are watching this, what is your understanding what it actually means? Now, let me read it out again, that neither party agrees to forego the minimum entitlements.
Yeah, okay, well, I mean, first of all, it sounds to me to be reference to what we kind of call the minimum code, contained primarily in the holidays legislation, but also the Minimum Wage Act and etc.
They're under the Employment Relations Act. It does refer to the minimum rights of people, and it does talk about that.
You can't contract out of that. So I'm not sure what a term saying that you won't contract out of it when you can't contract out of it means anyway. At best, it's probably, I guess, an educational reminder, but that's not the role of a mediator. The mediator's not there to remind parties what they're obliged to do.
Well, Chris, this is my understanding, and you've got far more depth of law than I have, but you can't contract outside a piece of law, legislation.
Well, you can if the legislation
enables you
to do that, but that's what a minimum code provides, is that you can't contract out of it. But otherwise,
explain to me why then is that Robin Arthur, one of the authority members, way back, set the pace on this, and somebody took a case up and said, I haven't been paid my holiday pay, the full amount of my holiday pay. And then he came back to him and said, well, you've signed this off saying that you've agreed that there's no, you're not foregoing any minimum terms and conditions, so you can't raise that claim.
Yeah, I mean, I'm not familiar with it, but it just seems at odds with the purpose of the legislation. I'm not sure that would withstand a careful reconsideration.
And I would agree again.
Court. Yeah.
So, we're now like, how many years is that? 8 years on, and every clause, like hundreds of thousands of settlement terms, it's in there, and that's where I'm saying this seems ridiculous because, I mean, does people understand the law like you do, and I have a softer understanding, but even I could see through this is an absolute ridiculous clause, and it's got common misunderstanding. People take from it what they want to hear.
Yeah, okay. So let's just take a step back. We're talking about what's known as a record of settlement, which is provided for in the legislation, where a mediator employed by the MB signs off a settlement agreement that's been reached by the parties. Now, the parties are free to enter into any agreement on any terms, provided the terms aren't unlawful. Okay. So the role of the mediation service there is only to explain that those terms are enforceable and binding and can't be otherwise challenged. Okay. But that's always going to be subject to the terms being lawful. So provided they're lawful, that's the end of it. Their role's not to say, and by the way, you have to add these clauses in as well, or we're not going to sign it. And I would have thought that if a mediator refused to sign an agreement because there wasn't this minimum
and they have often
term, then that's probably something that could actually be judicially reviewed, although whether someone would want to go to that effort.
Well, to hear somebody like you say this is quite a relief to me, because who's going to go to the problem? But it is innocuous that we've got this being forced upon the population by a government department, and the same government department polices the legislation and has effect to actually make changes to it as well. And nothing's happened in 8 years.
Well, it does seem to me to smack with a little bit of bureaucratic interference with the party's freedom to contract.
All right, then, let me put this challenge to you. An individual, and I've even got this situation, it was put in my path during the weekend, that's why I've got you here. So they signed off full and final settlement. They've signed off this clause, and then they were hoping that this clause enables them to raise a claim where the holiday pay is challengeable. 4 years of 4 years they've been working in this organisation, and they've been getting paid holiday pay as they go.
Sure.
So you can see where there's $16,000 at stake here.
Yeah.
Now, the lawyer on the other side's come back to them and says, tough luck, pal, you've signed off full and final. You can't go and get your legislation enforced. Would you take that case?
Well, yeah, look, the difficulty is it comes back to this, and I mean, every case has to be dealt with on its own merits, and individuals concerned need to take their own advice. But the way that I would probably look at a scenario, as you've outlined like that, is to say, is the clause unenforceable because it's either illegal or contrary to public policy? I would have thought it would be an unenforceable provision. I mean, no more enforceable than a contract that would say, look, you'll work for me for 20 hours a week and you get paid nothing, or in fact, you'll work for me and you'll pay me.
Yeah. Which
provision.
happens here.
Yeah. So, look, it's just the parties are, I guess, look at it this way, that they can enter into anything provided it's lawful, okay, and that not contrary to public policy. This is our common law, which, if you look at it as being like the floor upon which our legislation is I guess, the rug that lays over the top of it. Okay, so our common law is altered to the extent that the legislation says otherwise, and nowhere in the legislation does it say anywhere that the parties' ability to freely contract to resolve their differences is restrained, save as it's set out in the legislation.
So you made a comment there that the mediator's responsibility is to ensure things are lawful.
No, the mediator's responsibility is to follow what's set out in the section.
In the sections.
And the section says the mediator is obliged to explain to the parties the consequences of entering into the agreement, and in particular that it is only enforceable and they don't have a right to cancel. That's the extent of the limit of it.
Oh, okay.
Okay. Now, if it happens to be there are clauses in there that are unenforceable or unlawful, that's an issue between the parties that they may have to deal with the authority. It's not an issue for the mediator to step in there and say, oh, I don't think that that's an enforceable or because it's an unlawful provision.
Oh, because we get all the time that, say somebody says, I don't want my holiday pay, but I do want that big Section 1 1, 2, 3 because that's obviously tax-free and I'm getting a benefit from it. So we hear that every day. And, of course, the mediation service goes, you can't do that. You've got to pay independently. The holiday pay has to be paid. So we see it in some cases, and yet we don't see it in others. Do you think that this was drafted for the purpose of protecting the mediator and not the parties?
Sorry, what was drafted?
The wording of this is neither party has agreed to forego the minimum conditions. So that's an undertaking to the mediator to say that, we didn't know. But if naively they didn't know that they were being underpaid, and that's a possibility and often happens because the Holidays Act's very difficult to follow, is it possible they were trying to find a way to protect themselves rather than actually protect the parties?
I don't know. And actually,
no, you don't know. You said that from the beginning too.
Yeah. I don't know why they've done this. No. I mean, you said it's because they were concerned about a particular party, and it's kind of carried on ever since. So I just don't know why they've done it. I mean, you do raise an interesting point. Generally, outside of the employment realm, mediation is a contractual creature. The parties agree contractually to attempt mediation. And the mediator contractually agrees with the parties to provide mediation services. And as part of that, the mediator will routinely set out provisions where they disclaim liability and they have indemnity so they're not sued. What I've never actually looked at is, could a party or parties to a mediation provided by a mediator employed by the chief executive of MB, could one or both of them bring an action against MB for example, for negligence? Okay, or misrepresentation, some other claim, which I don't know the answer to that. It's probably going beyond what you're saying, but I think it links into your point about, is it there for protection? Well, just not sure that they actually need protection as such. I mean, they're providing a statutory role. I suspect that there's, without having looked into it, probably protected by some provision against getting. I've actually never heard of a mediator being sued.
No. I'm thinking of elected officials within council. They held personally accountable for breaches of employment law, and the answer is no. There's a section in there that says that they're not, but doesn't say that the officials, like government employees, could they be personally held accountable? It's an interesting question, and neither of us know the answer to that. No. Look, I've got a heap of questions here, but I think we've actually gone through them all pretty closely. Would you like to make any comments or things about this that might be helpful to our viewers to sort of, one, digest it, understand, and get your views? I mean, taking your legal mind, it's quite helpful to have you here.
Hey, Max, one of the things which I think is actually very important is if we think about how our laws are created, okay? The ultimate court, if one was to say that, it isn't the Supreme Court, it is our legislature. I mean, now we elect officials, we have a process, it's a parliamentary process that's lasted the test of time, and the courts and those that are subject to the law in terms of applying it, that's what they're there to do. What is I've been concerned about, particularly in the employment aspect for a long time, is where the authority and to an extent the court start effectively just creating law rather than applying the law that's actually there. Look, there is a line, and the line is that sometimes the law that has been created by the legislature, our statutes and our regulations need to be interpreted, and that's fine. And they don't necessarily get it right.
Not some, a large proportion of them, because they're non-prescriptive. That's the word that you and I understand. Non-prescriptive law just gives license to the judiciary to start making their own laws.
Yeah, or they come in
within the boundaries.
Yeah. Or they just come in and start in imposing, rules which just aren't there. And it's. Look,
this is fascinating, Chris, because you know what? One of the primary things I do is personal grievances, but one of the test of that is what would a fair and reasonable employer done in the circumstances. And when that first came out, and then they changed could to would, or was it the other way around? But either way, they said, we can't wait to find out what the courts say about this. So even the legislators didn't seem to even know what they were writing down and what it meant, and they were waiting for the court to come up with an interpretation. Now, isn't that giving license to the judiciary to decide?
Yeah, well, I mean, if one steps back and actually asks a more fundamental question, well, I'll put it this way. One of the fundamental tenets of a system of the rule of law is that the law has to be ascertainable, like you should be able to find it. Okay, we live in probably one of the greatest ages that anyone could ever wish for in terms of access to finding the law. I mean, putting aside the digital divide issue, if you have a computer, you can go on, for example, the legislation site, legislation.govt.nz, and you can type in Employment Relations Act and bingo, there's the act. Once upon a time you'd have to go to a law library or the government print office and buy a copy.
I recall that, yes.
Now it's all available for free, which is great. Okay, but the law has to be capable of being ascertained and should be able to be found, so that, for example, if you take employment law, employers and employees should be able to, without too much difficulty, find what the law actually is. And when you've got a provision, and this has been a problematic provision that's permeated through not just the current legislation but through previous legislation that's replaced it, is this concept of an unjustified dismissal. Okay, it doesn't state clearly so that someone can look at this legislation and go, oh, okay, I now know what the law is, what unjustified actually means, okay, and how that's applied. So the courts have interpreted it and created various tests that are to be applied. So you have to go and read all those cases. It's very fact specific, and often it'll depend on who's actually hearing those facts as to where that line is. But it's not satisfactory, because if the law is going to meet a fundamental tenet, it should be clear and be able to be discovered.
Okay, well then it's a great debate or great discussion. I mean, I'd love to hear a debate with perhaps QCs and yourself sitting up there. But what is better for society, to have a prescriptive type legislation as you're mentioning now, or one that's based on a set of principles that the enforcers will interpret and enforce in accordance with it, which can be challenged through a court. And basically that's where we're sitting today, but probably we're very prescriptive now, particularly in some laws, as we both know, and employment laws are pretty wide open in some areas.
Yeah, although with the unjustified dismissal, just dealing with that could actually be, to a large extent, a lot of the mischief that's caused by the lack of clarity around it could be resolved by just putting in some really basic fundamentals. Like, for example,
Oh, this would be interesting.
The legislation could state that to justify a dismissal, the employer must must follow natural justice and set actually what the elements of natural justice is. So an employer can go, oh, hey, I've just looked up the legislation. It said that if I'm going to make an accusation, I need to put it to the person that I'm accusing them of, this accusation, and give them an opportunity to respond to it. Okay, I mean, it doesn't require many words to put that in there, but it's a step in the right direction to say
yes, it is.
That's what's required. And likewise, if you then...
And that's a principle, really, isn't it? I mean, natural justice, well, they reckon good faith is another section of natural justice, but it actually is an enhancement of it, if you like, isn't it? But more importantly, the amount of injustices the amount of issues that an employee could do. I mean, I got one tonight where an employee was asked for an extension to his holiday. He was off in India, and that was rejected. And now he's saying, oh, by the way, my father's taken ill and I'm going to be staying here longer. Now, is that justifiable to dismiss that person because he was told he had to be back at work and he didn't come back because his father's ill?
Yep.
And that's really debatable. It's a discussion that, you and I could probably have at length. And the law can't prescribe those circumstances in every occasion.
Well, it can't. I
No.
mean, it can't prescribe it. In other areas of the law, just if we take the criminal law, for example, so there is the defence that people will be aware of self-defence, but self-defence is prescribed in terms of reasonable force, if one looks at that.
This is interesting having it from you, because you actually work under the Crimes Act as well, but that's a very small piece of legislation, and it is non-prescriptive, isn't it? And it hasn't been changed, and people seem to be quite satisfied. Am I reading that right?
Well, the statute first came in the Crimes Act in 1961. There have been amendments to it.
You wouldn't be born then.
Well, no, I wasn't even a twinkle in my parents' eyes. But the point of the matter is that there are other areas of our law where it can't be prescriptive, because you can't contain in a piece of legislation every possible scenario of human behaviour. So the word, and again, just sticking with crime, and which relates a lot to employment, is this concept of reasonableness. Okay, and reasonableness is, unfortunately, it's applied as an objective test with a hypothetical reasonable person in that situation. The situation and circumstances will be dependent by the facts, so the law can never capture everything. But what the law can do is it can stipulate and prescribe certain key elements. And look, the Employment Relations Act could provide more guidance so that employees can better understand what's required of them. So look, the biggest test with all of this, Max, is this, and I put it this way, is back in 1989 there was a labour law conference, okay, that was held in Wellington. Okay, there was approximately 20 attendees at that conference, lawyers, okay, because that was the extent of the amount of work that lawyers did in that
fraternity, yeah.
Well, and you just call it in the employment law jurisdiction. Well, it just wasn't a lot of employment lawyers, because there just wasn't the need, because for some reason, well, I know the reasons, well, many of them, is that employers and employees could just get along with each other, okay? And then Bill Birch came in 1991, and he gave to the legal profession what Woodhouse took away in 1976 with the ACC legislation, which was removing personal injuries. It led to an exodus of lawyers, mainly to Australia, got on the gravy train and doing personal injuries, and that was gone. But he just gave that back to the legal profession. And now, I think it's every 2 years, the New Zealand Law Society has an employment law conference. There are literally 350 lawyers attend it, because it's a big industry.
That's huge.
Okay, and why has it gone in the space of, in the space of 30 odd years? Why is it growing so much? Okay, well, it's growing so much because of the uncertainty that's placed in part in the legislation, and that uncertainty could be just clarified by just setting out some basic.
Can I take
principles.
you back to where we drifted right off this matter, but certainly one thing that's worried me for a long time, and I'm very pleased to have this opportunity here to talk to you, but Lord Cook in the UK said common law is out of the reach of the common man. And I understand that now, because I'm finding employment law is now out of the reach of the ordinary man and the woman in the street, because of the cost of it and the complications with it, and everything can be challenged. And we find that even the Employment Authority, which is supposed to be a low-level judiciary, if it is a judiciary, was supposed to deal with things to keep it so it was reasonable and the man in the street could go represent himself in there. And it's gone way beyond that. The Employment Authority has been described before. It thinks it's a mini High Court and imposes all these rules and regulations and requirements and forms on people that it's just too hard for the layman to step into. Just going back to where we started, law, is it prescriptive or non-prescriptive? What's best for our society? And that's
Okay.
a big question.
Well, it actually just goes back to, again, we need a mechanism to resolve disputes in the workplace.
Truly.
Because conflict in the workplace is inevitable. Okay, there always has been conflict, and there always will be, and you can't leave it to just the parties to sort out, because ultimately it produces unfair outcomes, and that's generally what laws are, is about regulating behaviour to ensure that the outcomes meet policy. So New Zealand's had a great tradition of providing a state-provided dispute resolution mechanism in the employment context, but it is terribly gone astray. First of all,
Agreed.
not only is the Employment Relations Authority, it has a status that's effectively the same status as the Supreme Court. And the reason why I say this is because it has an unlimited jurisdiction, okay, in terms of money. So it's got a higher jurisdiction than the Disputes Tribunal. It's got a higher jurisdiction than the District Court, okay.
Is it right?
Well, because it's got unlimited. The District Court's monetary jurisdiction is capped at $350,000.
Oh my God.
There's nothing stopping an authority member going, oh, I'm going to award you $2 million or $400,000. So it's got an unlimited jurisdiction. It can stipulate whatever processes that it sees fit. Now that can be a benefit, an advantage, but it can be a disadvantage as well. But the real kicker on it, this is the real kicker with the authority, is that it's not subject, like the Supreme Court, to review. Okay, so you can't go to the employment court and say, hey, the process it followed was manifestly unfair. You know, like so you can't have it reviewed. Right? So they could just do whatever they like, and that puts a lot of power there. Now, so I guess that's one point. The other point is that if you think about what the objective of what it's supposed to be, which it's supposed to be a speedy, informal authority that produces just outcomes, and then you benchmark that against, for example, you benchmark it against the Disputes Tribunal, as an example, and say, well, how quick does it take to get a determination, and how much does it cost the parties? Well, if you compare it to the Disputes Tribunal, it's an absolute monumental failure by a large extent. Huge failure. Now, keeping in mind the Disputes Tribunal jurisdiction, okay, is, if I've got this right, it's 20,000 unilaterally, so a claimant can bring a claim up to 20,000, and the respondent, you know, is stuck in that jurisdiction, or by agreement they can take that to 30. Now, I understand that the move is they want to move that further up to 50 or possibly 80. Now, a lot of employment claims fit within that range, okay? And if you file a claim in the Disputes Tribunal, you can expect that you will get a determination issued by the Disputes Tribunal within anywhere between 2 to 4 months.
Yeah, agreed.
Okay?
That's my experience.
Right, and that's pretty much the end of it, okay? There is no general right of appeal, okay? So it doesn't perpetuate on to the district court. But in the authority, of course, it can go to the employment court and it's all de novo, so you start all over again. Okay, put that issue aside. That's probably for another day to talk about whether that helps with the policy of a speedy dispute resolution mechanism. But the other aspect of it is that there's no costs, okay, because the parties aren't allowed to have lawyers there at all, okay, so they can't have representatives.
No.
And it is just a way of going, if you can't sort it out amongst yourselves, then we'll hand you a resolution. It may not be, 100% right, but it doesn't matter. It gives you a resolution to move on. But at least you're not stuck in a situation where the medicine or the cure is worse than the disease. And that's the problem in the employment process, when you've got parties spending.
My view is that the Disputes Tribunal, that concept, and I don't even know why we've got an independent employment one, but that could take over from the employment mediation service and the authority and start operating as it does now. And it would be quick, easy, cheap, and most parties will get some resolution through it in a very fast and effective way.
Yeah, I mean, I think my view on it is that if a claim, and it should be subject to some scrutiny, is under a particular amount, let's say 20,000, for example, why not have a process like the Disputes Tribunal?
I agree totally.
Just de-lawyer. You see, lawyers weren't allowed in the employment, specialist employment court, or called the Labour Court back then, up until 1991. I mean, for nearly 85 years, lawyers had to get the leave to be there because, to an extent.
So go back to Lord Cook's statement. That's a resolution in one. And it is, and I quite like it. I think it would be a very powerful and very easy way to resolve where the employment law is. I mean, I've even advocated it to act exactly what you've just said.
Yeah, I mean, if it was beyond a certain level, what I think would be a much better process that would serve employees and employers
much better.
Okay, is a model similar to the adjudication regime under the Construction Contracts Act, which specifies the steps that need to be taken and the time in which they're to be done.
Oh, right.
Okay, and it gets matters resolved incredibly quickly and, relatively speaking, cheap. And some of these matters are...
Can they be appealed?
So you do have a right of appeal.
And can you have representation?
Well, yeah, and you can have representation, but there are limits. But the key thing about it is this. Experience has taught me, okay, that the longer that matters take to be determined, okay, well, let me just take a step back. In any dispute, there's only three possible ways that it'll resolve, okay, and there's no other way, okay. One is that the claimant, and if we take the employment area, it's generally the employee. I mean, employers can claim as well, but let's just say the employee, for the purpose of this, decides for whatever reason to abandon their claim. Okay, well that's a resolution because the matter's over at that point.
Yeah.
Okay. The second way it can be resolved, there's three ways. I've mentioned the first. The second way, which in my experience, the large majority, 9 out of 10, if not 19 out of 20, are resolved by agreement. Okay, and that, generally speaking, that's the best way to do it. Okay. And then you have the small number that is the third way, and that is where a third party hands the disputing parties, the employer and the employee in this case, their resolution. Sometimes punishment for one or both of them being unreasonable and trying to get it resolved. And that is generally, at first instance, the authority. Sometimes it can go straight to the court. And it's generally, if it's the authority, it's a determination. They hand it to them. Now, that determination from the dispute being referred, usually by an application to the authority and the handing of a determination, that needs to be done quickly and in an inexpensive way. And if it fails to meet those objectives, then the system is failing. There is a problem in our processes because no one is going to say it's good for the employer, the employee, and our economy to have these long-winded, protracted disputes. So there's systemic failures in there need to be resolved.
You're telling me. I've had an issue which took 5 years. Look, Chris, thanks very much for everything. We got into some depths and way off tangent here, but I mean, I think it's fascinating. Yeah. And have your brain here is quite handy to lock into it about all sorts of things. You better come back sometime.
Yeah, we should. Yeah, I'd love to.
All right, let's do that.
Good to see you, Max.
You
Good
too.
to have you. Thanks.